This is Michael Popak with a breaking news story. Donald Trump is trying to drag his state conviction, 34 count felony conviction, across to federal court for the second time to avoid being sentenced on the 18th of September by Judge Juan Merchan, a judge that he can't wait to get away from. This is now the second attempt by Donald Trump. The first one failed. The second one will fail, and we'll go over why in a moment. But what has happened in the last 24 hours? Two things. One, we now know why MAGA Congress went after Judge Juan Merchan's daughter and has asked her, demanded that she turn over personal and private financial records about her company that operates for Democratic causes. Has nothing to do with the judge, just has to do with an adult daughter who happens to have a job. But now we know why MAGA Congress, at Trump's urging, issued that a couple of days ago. It was cover for this new notice of removal, second notice of removal that Donald Trump's lawyers have filed before a particular judge in the Southern District of New York federal court named Al Hellerstein. This is the second attempt by Donald Trump to drag his case out of state court and get it away from Judge Juan Merchan and over to federal court. It failed the first time. We reported right here and talked about it on Legal AF that back in May through July of last year, Donald Trump tried the exact same thing. The primary focus in this new notice is the same as the last notice that failed. It's that Donald Trump was a federal officer who, under his official color of his office, committed the crimes that are alleged, and now not even alleged. Now he's convicted of those crimes, and therefore he had the right to have his case tried in federal court, not in state court. It's a little different than a total immunity argument. He's not arguing that he's immune from prosecution because 2/3 or 3/4 of his activities happened while he was a candidate. He wasn't even president. So even he doesn't argue that. His main argument is there were certain pieces of evidence about the continuation of the hush money cover-up affair with Stormy Daniels and the payoff through Michael Cohen of that money that happened after he got elected. In other words, when his election interference actions were successful and he actually became president, there were certain meetings he held and certain statements that were made and certain evidence that was presented at the trial. Donald Trump has an argument, I assume, and he's made the argument to Judge Merchan that those pieces of evidence corrupted the whole outcome and is reversible error, that those pieces of evidence and testimony about what he did or what people did around him when he was president, based on the United States Supreme Court precedent of Trump versus the United States, should never have been presented to the jury in New York, the 12-person jury. And his claim is they wouldn't have convicted if they didn't hear from Hope Hicks, the press secretary, or the person that was responsible for scheduling Donald Trump's calendar and lunches. I don't think that's how that case went. We followed it pretty closely here on Legal AF. So the argument now to Judge Hellerstein for the second time is, look, Judge, there's all these bad things that happened at the trial.